appeal in the matter of Fertre and Vale of Whitehorse District Council and others.
Yes, Mr. Cox.
Good morning, my lords, my lady. I think the Secretary of State has some additional documents and notes for you.
Well, we have had those, and subject to any views to the contrary, submissions to the contrary, it seems to us the right way to deal with this is as follows. Clearly, we've had no opportunity to read this properly, seen the sort of thing it is, but we haven't digested it. The same may be true of you. It may well, you may well want to have an opportunity to say something about it. We may well want to follow one or two points up with Miss Smythe and possibly with Miss Ward. We can, though we would rather not, sit for part of this afternoon. I hope that is also the case with Council. What we would therefore propose to do is hear the rest of your reply on round one and saving any points that emerge out of the new material. Then hear the submissions on round two. And we will then take advantage of the short adjournment to read Ms. Smythe's note more fully and think about what we may want to follow up from the debate on round one in the light of that note. And we will then sit again at 2 and have no more than an hour, quite possibly much less, but certainly no more than an hour for what I might call follow-up points on round one in the light of the note. Does that work for everyone?
That works for me, my lord.
My lord, yes.
Sorry. I'm based in the north of England, my lord, and at the moment I might experience childcare difficulties.
Well,
I'm not asking.
No,
I'm only asking for permission to be excused.
Of course, you will of course be excused. Nobody need attend except for those who might be entitled to make submissions on this point, and that really only means Ms. Smythe, Ms. Ward, and Mr. Cox. So others may want to be here.
I appear in any event with my junior Mr. Bishop.
Very good.
So I'm simply asking for permission to be excused.
No, permission granted. We've given some more thought to Mr. Burton's request at the close of business yesterday, and while we understand the thinking behind it and not unsympathetic, thinking about it a little bit further, it of course begs the question of whether we are going to remit round 3 if it arises, or retain it here. And that itself is, if it arises, not a straightforward question on which we will, I think, parties will want to make submissions, and we may want some help, and we will want to have understood the case on justification slightly more fully than we have in our simply by our pre-reading. That being so, I just don't think it's realistic for us to make it, well, either to hear submissions on whether it should be remitted at this stage. I'm afraid those will have to be post-judgment, post-hands-down submissions. The parties may want to start to think about it, because we will, I'm sure at that point, if it's relevant, ask for brief written submissions. We might even reserve the right possibly to have a short oral hearing on the point if it arises. That would all be before the end of, when I say term, I don't mean this term that's about to end, but before the end of the Trinity term. Good.
So, my lord, then I hear what your lordship says, and with great respect, it sounds very sensible. I do wonder, though, whether or not there might still be merit in Mr. Burton's suggestion that we try to find a space.
But the point is, you won't know in which court you're trying to find a space.
That is true.
That's the real difficulty.
Yes.
And I think it's
so it would
for
be
for the sake of a contingent possibility of saving, and I understand the difficulties, of course, but of saving a few weeks in making those arrangements, to make contingent arrangements in the KB and contingent arrangements in the Court of Appeal, I think it's disproportionate, quite frankly. If it arises, you can be assured we will try and give a following wind insofar as within our power to getting an early hearing on the justification point.
Well, I'm grateful, my lord, and I don't seek to persuade you that it would be.
Okay, well, thank you. Off we go with the rest of your reply.
Thank you. So yesterday I set out 5 steps, stepping right back. In my submission, really only the last 2 of those are contested in these proceedings. And I would frame those a little more precisely than I did on the hoof yesterday, as the first one being the extent to which the United Kingdom granted immigration residence rights when implementing Articles 13 and 18.
Sorry, can you just say that again?
The extent to which the United Kingdom granted immigration residence rights when implementing Articles 13 and 18. And the outcome under Article 23 in light of those residence rights.
You use the phrase immigration rights,
Yes.
but residence rights, you mean the same thing?
Well, I'm narrowing it to immigration rights.
Well, I'm fine, but I'm sorry, I thought you then
Sorry,
rephrased it as residence
my
rights.
apologies. In light of those immigration residence rights. Yes.
Okay.
And the fact that there are 2 steps and not a single one is important, because while the Secretary of State and the IMA are adamant that the outcome is the same, that can only be so if they're right either about the first step, the immigration step, or the second step, the equal treatment step, as far as issue 1 is concerned. Of course, even if we get over those hurdles, there's then the question of whether or not it is actually unjustifiable or unjustified discrimination. But for the purposes of issue 1, they must either be right that, as it were, when the appellant emerges from 13 and 18, travelling down the scheme of withdrawal agreement, she isn't residing on the basis of the agreement for the purposes of Article 23.1. Or they're right in their narrow reading of Article 23.1 that even people who textually are residing on the basis of the agreement, they've got an immigration right under 13, are not to be understood to be residing within their constrained reading of 23. So, and I say what they do in what's happened in the Secretary of State submission is conflating those and essentially saying the outcome has to be the same. The states can't have intended to change the outcome. But once we break it down into the 2 parts and we look at this from the perspective of states' power under immigration and states' duties under equal treatment, in my submission we can see that the outcome is different. So in my submission, what I want to do within my reply under the first step, immigration rights, is 4 points.
You are aware you've only got a quarter of an hour left.
Yes.
Rather less than that.
The first point, can an EU citizen have a right to reside under Article 13 at a time when they do not comply with all the conditions and limitations in Article 13.1? We say yes. The IMA agrees, taking the position correctly, we say, not just in principle, but on the facts of this case. Pre-settled status means that Ms. Fertre is exercising a right of residence under Article 13. Now, in the course of my submission...
Which right of residence under Article
Sorry?
13? Which right of residence?
Well, that's a good question, and I'll try and turn to that, but that's an answer the IMA doesn't provide.
What's your answer?
My answer is it's the exercise of the right of residence under 13.1 by benefit of the waiver of the limitations and conditions in 13.
I'm sorry, I'm struggling to hear you.
I'm so sorry. It's the
You
right.
seem to be addressing my lords.
I'm
It'd be
so
quite
sorry,
nice to have
Mary.
some over here.
It is the right of residence under Article 13 because the limitations and conditions in Article 13.1 have been waived under Article 13.4 by the grant of PSS.
That doesn't make sense. The rights under Article 13 are all rights defined by reference to the treaty or to EU legislation. So
Yes.
there is no such thing as a right under. You've got to be able to say which of those.
Well, then if we're bringing in that historical, it's Article 21.
Yes, I see.
So we're up back to Article. That's the point. Article 21.
Yes.
Okay.
Oh no, sorry. Yes.
But
yes,
that's a different analysis from the IMA analysis, isn't it?
Well, my point is that the IMA go to the end and say, without explaining how, my submission, that Miss Fertre didn't just have a right to be protected from degrading treatment under the Charter, that she had a prior underlying right of residence under Article 13, and that's why she has protection under the Charter. Now, I want to deal first with the point about in principle.
Well, are we now still on your first point?
We are.
Okay.
Because it was put to me on Wednesday, well, why would the states want a power under the Withdrawal Agreement to waive the conditions and limitations under the Withdrawal Agreement? Why wouldn't they just do it?
If this is a point we put to you and you answered then, I mean, this is a reply, Mr. Cox. It's not an opportunity to make all this
I
again.
understand.
Okay.
My point is that Ms. Smythe did not dispute my approach. She didn't argue that the states wouldn't want or need a power to keep somebody under the Withdrawal Agreement by means of a waiver. On the contrary, and crucially, she agreed that the states do want and have that power in principle. She expressly accepted that the states could waive limitations and conditions under Article 13.1, and she gave the example of waiving the requirement to have comprehensive health insurance. Now that's a radical departure from the position below, which was we can't do that. We can't keep you under the Withdrawal Agreement if you're not complying with all the conditions and limitations under 13.1. And she presented that as if it was obvious that states would want that power. She's right. It's obvious. It's obvious they want, and it's obvious they have. We're not talking then about do they have a power. We're just talking about the limits of the power.
Which power are we in? 13.4 power.
I say it's 13.4. Ms. Smythe, when pressed, didn't say what it was, but when in reply to my Lord Justice, Lord Justice Newey, when asked whether such a person whether the beneficiary of the discretion to waive those limitations and conditions would still be residing under the Withdrawal Agreement, she said yes.
I'm sorry,
I
I
just
feel
bit
that my
lost, actually.
submission's being misrepresented here.
Well, we've got a record of your submission. I don't think you should assume that when Mr. Cox says what your submissions were, we necessarily agree that it's a correct characterisation. But time is short. You don't need to.
Thank you.
Certainly, I understood the Secretary of State to be saying that it was obvious that states would want to be able to modify, to exercise discretion in the case of the conditions and limitations under Article 13.1, and that would not ipso facto take that person outside the scope of Article 13. Certainly no argument was advanced that they wouldn't want to or need to. And the IMA agreed with her submissions on that. So my submission, there's no longer an issue between the parties about whether the states can keep someone under the Withdrawal Agreement, Article 13, by the exercise of a discretion. Second point, where in the text is the power to do it?
This is your second point of your four.
Yes.
Okay.
It's in Article 13,
To do what?
to waive the limitations and conditions in Article 13.1. It's in Article 13.4.
Not in. Why not in? Why not in 37?
Because that wouldn't keep
Or do I
someone
mean
under the withdrawal.
38?
That wouldn't keep someone under the Withdrawal Agreement. They wouldn't be residing under the Withdrawal Agreement. The state would be faced with all the complications of being unable to operate the same scheme under EU law that it operates under the Withdrawal Agreement.
Okay.
So the next point then is, why isn't the power large enough?
This is your third point.
Yes.
Thank you.
Is the power large enough to extend to the waiver effected by the PSS? Well, no one has articulated any principled boundary on the power to dispense with the limitations and conditions under 13.1. Not suggested that the limit on the power is the Charter. The example of health insurance waiver shows that. There's no textual basis for a limitation on the power. And there's no purposive basis for a limitation on the power. It is, after all, a power in the states that they can choose whether or not to exercise. It's certainly not limited to a case-by-case consideration. As Smythe expressly made the point, correctly, that the UK or a member state could adopt a policy on the exercise of waiving limitations and conditions under Article 13. So turning then to how that works quickly, if I could ask your lordships just to quickly turn back up CG at 87 to 88, page 407 of the report, because there's want to just
Could you give me the page number again, please?
407. My lords, it
Which
may be
paragraph?
87 and 88.
Yeah.
These are about the immigration residence rights. They are not about benefits. And that is the last sentence in 87. In so doing, and that is in so granting PSS, those authorities recognise the right of a national of a member state to reside freely on its territory, conferred on EU citizens by Article 21(1), without relying on the conditions and limitations in respect of that right laid down by Directive 2004/38. That's the immigration right that is conferred by PSS under EU law. And when we see at 88, it follows that then they implement the provisions of the FEU Treaty and that they are accordingly obliged to comply with the Charter. It isn't the Charter that required them to grant a right of domestic residence. It's that having granted a right of residence, the Charter became in play. And the route to the Charter is through immigration rights under Article 21.
Residence rights.
Yes, immigration residence rights. The
So I
right
don't
to-
understand what you mean by immigration residence rights.
Well, I mean, sometimes the residence rights is used in a more broad sense about equality and so on. I mean a right to live here.
Well, that's all I mean by residence rights.
Then we're on the same page. So turning then to 18, which is, and in particular at page 1385,
Is this your third point still?
it's still my third point. If I might borrow some time from my opening on issue 2.
Well, issue 2 is important, and I don't really want us to take it as we're going to have to take it quite tightly anyway.
Yeah,
You haven't exactly been succinct. Sorry,
sorry.
that's just ruder than I mean to mean. These points
No,
to be made quite
I will
crisply.
make them more crisply, my lord. 1385, paragraph 89, and it's the court's agreement with what the upper tribunal said. There's been a conflation, I think, accidental conflation in the submissions between, 1385.
Keep going, I'll find it.
There's a conflation between what the Home Office did and what the Secretary of State for Work and Pensions did. So in opening words, the UK was implementing Article 21 when granting CG a domestic law right of residence. That's what the Home Office did. That's the immigration stage of the analysis. The Home Office didn't give her that because of the Charter. They gave it in implementation of the Withdrawal Agreement. CG also establishes then that the benefit authority is acting in the scope of, and let's see how the tribunal describes what the Secretary of State has done, the Article 21 TFEU right to reside, necessary to make that right effective. And then we see the tribunal describing the right, the immigration residence right. 80's modified Article 21 right to reside, the right conferred by Articles 10 and 13 of the Withdrawal Agreement. How is it modified? Well, it's modified by the grant of PSS. So the immigration step of showing that AT had a right of residence turned on CG about Article 21. This court's conclusion that continued to apply under Withdrawal Agreement 13. So that's the immigration part of AT. When the court turns to the benefits part, it does so on the basis of the charter argument. It doesn't need to look at the extent of the appellant's rights or conditions and limitations on them. It takes as given that there may be conditions and limitations, and it says that they can't be applied in breach of her charter rights. This court, therefore,
We haven't even got to your point 4.
Sorry, my lord. I do apologise. I had 3 points under Article 13. I'm sorry. So this is.
You told me you had 4, but it doesn't
I'm
matter.
so sorry.
No, I don't mind
I'm
at all.
going as quickly as I can, my lord.
Well, you're not going as quickly as you can. So you may just have to stop. But
Right. Very good.
just
This court. Okay, then I'll make it.
let just have, if there's anything crucial you have to say, rather than just developing the points we've heard before,
I'm sorry.
by all means say it. But
I wasn't trying to do that. I was trying to clarify, but I'll just looking at my notes. So it falls to this court to decide the question that didn't arise in AT: what is the extent of the modification of the right to resign? There's nothing in Article 13 that precludes that. Quickly on Article 18, Secretary of State says that Article 18 is to be interpreted so that the grant of PSS is not that waiver. There's nothing in the Commission's submissions that the Secretary of State agreed with that refers to Article 10, or says it's simply a document under Article 10. You have my submissions that the location of Article 18 and the text of Article 18 shows that it is concerned with conferring Article 13 rights. It's therefore the occasion of the Article 18.1 document is the occasion on which a member state may properly, and has in this case, exercise its power under 13.4 to act more favourably and dispense with the limitations and conditions.
how much longer are you proposing to be, Mr.?
That's it, my lord.
That's it. Nothing else. Article 18 is it. Very well.
Thank
I'm
you.
sorry. I'm sorry if I've been stern with
It's
you,
important that we give it proper time to each issue, my lord.
well, that's right. And I mean, I see that, admittedly, if what was expected to be ground 2 and ground 3, you were given 2 hours. Well, we haven't got 2 hours. I mean, effectively, you're going to have to deal with ground 2 in an hour to give time for reply.
Yes.
Yeah,
No,
good.
so there was a modified timetable.
Oh, was there?
Between departments.
Did that
I'm so
reach
sorry.
us?
I don't think it hasn't reached you. I'm so
I see. Well, okay. What's the proposal under the modified timetable, just so that we can keep an eye on it?
One second. I think my my submissions on ground 2 will finish at 11:35.
Okay.
The Air Centre has 20 minutes.
Yep.
To 11:55. The Secretary of State has 50 minutes to 12:45. I have 10 minutes for reply, and then 5 minutes for housekeeping.
Okay. Well, off we go. So
I will follow in my submissions on issue 2, ground 2. I'll follow the structure of my skeleton argument. Page 18 of the skeleton, which is page 71 of the core bundle.
Could you give me the paragraphs we're looking at?
Certainly 87,
87.
starting at 87. Again.
yeah,
I misspoke when I did the page reference. It's 133. I'm sorry.
no problem.
So I've set out the text of Article 23 there. You've already had our submissions under Article 1, sorry, Issue 1, as to what, in accordance with Article 24 of the directive, means. Well, my submissions here fall into 2 parts. My submission, I make submissions on 2 points, but there are 3 parts to what I'll be saying. The first is to set out the domestic scheme for eligibility. The second is to show that on the correct construction of Article 23, this category of discrimination. Discrimination on this basis is incapable of justification because it would constitute an implied additional derogation from 23(1). And just to preface that,
Well, if your time is short, why are you prefacing it? People spend a lot of time trailing things in this
I
course.
won't
I
trail.
want to get to substance.
yes. So as I set out at 89, there's no dispute between the parties that this is social assistance, and it's not been argued at 23.
Sorry, which is your third point?
I'm
One is your initial is the domestic, not your heading. One is the domestic scheme, that'll be
sorry.
helpful. Second is discrimination on this basis is unjustifiable because it would be a further derogation
yes. And then
over and
thirdly,
above 23(2).
thirdly, I address the historic case law under which the courts have previously found that this was indirect discrimination, or
Yes.
similar.
No, that's fine. That's what I understood your points to be. Okay, off we go. So we're going to A, is that right?
We are.
The
The
domestic
domestic scheme of eligibility for homelessness assistance at 91.
Yes. Now that's what I haven't, because it's extremely difficult and we haven't been given the references here, quite worked out how this works, but you're going to helpfully do that for us.
I'm going to try. It is complicated. Though I think it's fair to say that the intention, and I think it is subject to the argument that I was not given permission to argue, it is achieved by the domestic scheme, is that it tracks rights to reside under EU law
Right.
for this category of people. Now, how it fits them into
When you say this category, what do you mean?
for EU citizens.
Trended to track rights under EU law for EU citizens.
Yes.
Oh, yeah, okay.
So what it does essentially is recognise a right to eligibility for those who have a qualifying right under EU law.
Hang on 1 second. What do you mean by qualifying right under EU law?
A qualifying right is one which would prohibit the United Kingdom from denying social assistance. Or to put it another way, if the person has a right to reside under EU law, which was not lost by recourse to social assistance,
Say it again.
if a person had a right under EU law which was not lost by recourse to social assistance, then they are eligible for homelessness assistance.
Not lost by recourse by a ban.
Recourse to social assistance.
By recourse. Okay. Well, you're going to make that clear.
I'm going, yes. But the complicating factor is that these rules are located in a larger scheme which seeks to govern the rights of the eligibility of everybody to homelessness assistance,
Yes.
including British citizens and non-EU citizens.
Yes. Well, you're going to show us that. That'd be helpful.
Yes. So the first point to note is that persons who require leave to remain and only have limited leave to remain are persons subject to immigration control. And we get that from section 13(2) of the Asylum and Immigration Act, which is in the notes that is attached to my skeleton.
Sorry, I don't want to be unhelpful. If that's, doesn't it make more sense to start with eligibility under the Housing Act and follow it through step by step?
Well, this is a component of eligibility. So
Okay, all right.
the eligibility scheme reads in section 13(2). So this is a primary definitional distinction. A person subject to immigration control is a term.
All right, I'm sure you've thought out how to do it, but you'll just have to make it easy for us.
Of course.
The complaint here is I was treated as ineligible for homelessness assistance.
Yes.
That's the act complained of.
Yes.
So surely the first thing to see is the provision that makes you ineligible.
Yes.
What is that?
Well, that's a set of complicated web of provisions that I'm trying to take your lordship through. There is, if I take,
No, do it your own way. Do it your own
There
way.
isn't a discrete provision that makes.
Well, I thought there was. I thought there was something in the Housing Act which says you can't have homelessness assistance if you're ineligible. It's section 1852, isn't it?
Sorry, we can certainly go right. We can certainly go back to that, my lord.
Well, sorry, that's what I wanted to do. It maybe it's obvious to
No,
you, but
absolutely.
if we don't fill it in, we'll get lost.
Yes, no, I hear your lordship. So I shall absolutely take you to that.
Okay, so
So there we are.
it is 1852,
It
isn't it?
is, and it is at page
22.
22. Thank you.
Yep.
So 1851. A person is not eligible for assistance under this part if he is a person from abroad who is ineligible for housing assistance.
Is the term person from abroad defined?
It's not, and it is.
It's an odd term, but
It is constructed out of regulations. And then the second clause, a person who is subject to immigration control within the meaning of Asylum and Immigration Act 1996 is not eligible for housing assistance unless he is of a class prescribed by regulations made by the Secretary of State. So these are a framework scheme from Parliament that leaves the content of it largely up to regulations.
I mean, the way it's drafted makes it look as if 1851 and 1852 are separate provisions.
They are.
Indeed.
They are separate provisions.
So what's the one that bites in this case?
Well, it's two because the applicant, well, as we shall see. So shall I take you to the definition of person subject to?
In a minute. So we don't need to do 1851 at all.
Well, you need it for context.
Decision letter said this is a person from abroad.
You need it for context.
But just suppose you are subject to immigration control within the meaning of the 1996 Act.
Yes.
And you don't fall into the prescribed class.
Yes.
That's what excludes you.
Yes.
You might or might not also. 1851 doesn't exclude you by itself. It's true you're a person from abroad, but then the question is, are you ineligible for housing assistance?
Yes.
Which is presumably a term defined somewhere else.
But the content of it is provided in the general scheme. There are transitional provisions by regulations 5 and 6 of the eligibility regulations.
And where is there a subsection somewhere which says ineligible for housing assistance is defined by regulations?
No. What there is under 5. A person falls within this subsection. Oh no, I'm so sorry. That's a different. That's not. There is a general regulation making power in the Act. Yes.
Okay, I'm probably being stupid about this, but I'm annoyed that time is short. For I just want to understand the structure of 1851. You might think that of 185, that as it were, 185 says all that's need to be said, and the rest is just defining ineligible for housing assistance. But that's not actually how it's written.
No, that's not complete. I agree with that, my lord. There is a structure to it.
Okay. Well, let's not spend more time on it for the moment. You say that what is cutting you out is 1852.
Yes.
So does Mr. Burton.
Yes, Mr. Lewis. But just to pick up, as my lady observed, subsection 3 says may make provision by regulations as to other descriptions of persons who are to be treated for the purposes of this part as persons from abroad who are ineligible for housing assistance.
But that's not relevant if it's 1852.
That's right.
That's biting on us.
That's right. So, can I show you then the definition?
Okay, so then the next bit is easy, isn't it? I don't want to. This bit I think I have understood, but tell me if I've got it right. There's a definition of person subject to immigration control,
Yes.
which basically everyone agrees that Ms. Fertre became, at the moment we left the EU, subject to any further provisions.
Well,
Am I wrong about that? Well, okay.
No, that's not right. We would agree that she became, because of the point rejected below, we would agree that she became the person subject to immigration control when she ceased to have a right to reside under Article 6.
Yes. Because, well, isn't this the way it went? Basically, anyone who wasn't a UK national and didn't have a right to reside here was subject to immigration control,
Yes.
unless they'd been given indefinite leave to remain.
Well, no, anyone who wasn't a UK national, subject to immigration control, including those people, but not within this definition, unless they were exempt from immigration control by virtue of possessing EU law residency.
No, I hadn't got that far. That's the common law position. Then, when we joined the EU and signed up to freedom of movement, there was Section 7 of whatever Act it was, the 1988 Act, which said that persons exercising their rights under the treaty, effectively, to reside here, were not subject to immigration control. That was repealed with effect from 31st from IP completion day.
Yes.
Right. So now we are looking at, and at that point, subject to any other provisions, which is where it's difficult. At that point, she became prima facie a person subject to immigration control, and we have to see what how that was modified in the post-Brexit settlement. Is that
all EU citizens became persons subject to immigration control in that extent? To that extent, unless they had indefinite leave to remain.
Yeah.
And that is why the savings provisions matter.
Exactly right. So that's the structure. She she is a person subject to immigration control because she's an EU citizen, as from the 31st of December 2020, subject to a complicated parcel of savings provisions, which may or may not.
Well, subject to actually, and once they're complicated, but not really a parcel, a single savings provision,
Okay.
then brings in a complicated set of.
Well, okay, let's see what those provisions are. So that's what I haven't understood.
251 is the straight transitional provision, paragraph 5.
So which page?
251.
251, thank you.
What are we in? We're in Schedule 4 to what?
We're in Schedule 4 to the Immigration and Social Security Coordination EU Withdrawal Act 2020, consequential saving, transitional and transitory provisions, open brackets, EU exit, close bracket regulations. Titles are 241, Malik.
So I see we haven't got the title page to that.
You have a 241.
Is that the title page? Oh, no, it's Regulation 83.
It's not the title page, it just has the title.
Yes, could someone send us later we don't want the whole regs, but we just like the title page so we can see the structure. Okay. Regulation 83 gives effect to Schedule 4.
And Schedule 4, paragraph 5, has this text, notwithstanding the repeal of Section 7 of the Immigration Act 1988.
That's what I was just referring to, yeah.
By the provision repealing it, a member of the post-transition period group is not to be treated as a person subject to immigration control within the meaning of Section 13 of the Asylum and Immigration Act 1996 for the purposes of the exercise of the functions specified in paragraph 6. Then two definitions are found over the page of paragraph 6. Paragraph 6 defines the functions specified, and so that's the housing ineligible for allocation.
Okay, so it's 6A for the housing assistance on 1852.
Yes, and the definition of the transitional group is to be found at page 242 in the first paragraph of the schedule.
Okay, hang on 1 second.
essentially
Yeah.
means someone with PSS, limited leave to enter, under resident schemes immigration rules. I don't propose to take you to the definition, resident schemes immigration rules. It's common ground they're defined in the 2020 Act as in a way that means it applies to PSS.
Okay, that's very helpful. So basically, Regulation 5 deems
Paragraph 5.
people with PSS, or paragraph 5 deems people with PSS as having as being not being subject to immigration control.
Well, you might think so, but that's the
yeah, I
argument.
know, but there's obviously some other complication. But
That's the argument that was rejected.
I know, but and you're about to show us why, through gritted teeth, why it was rejected.
Well, it was rejected on the alternative interpretation of this provision is that it means, my friends may put it better than me, those to whom Section 7 of the Immigration Act would have applied are not to be treated as persons subject to immigration control. I said that isn't what it says. I said
That's not an argument we're making.
sadly not.
So Regulation 5, as the law stands.
As Mr. Justice Jay held,
Yeah.
means
As the law stands.
means that a member of the post-transition group is not to be treated as a person subject control if they were a person who would have benefited from Section 7 of the Immigration Act had it not been repealed. In other words, he held that this splits the class of PSS holders into two groups: those with a enforceable EU law right to, or would have an enforceable EU law right to reside if we were still in the EU, and those who, like Mr. Fertre, who don't.
Because they don't satisfy the conditions.
Because, exactly.
Right.
Now, Ms. Fertre, it's accepted that Ms. Fertre, even with PSS, would not have had an enforceable right to reside under Section 7 because she could have not have stopped the Secretary of State from taking her PSS away. She did pro tem have a right to reside under Article 21, but we didn't argue that it was a Section 7 right. We did make an argument about the construction.
You mean
of
section? You mean? Oh, I see. Yes, right. Yep.
You call the other sort of right a residual right.
Supererogatory right? I don't know.
Yeah. All right. You say she had an Article 21.
Yes. Oh, certainly. Yes. But it wasn't one that the treaty alone gave her, or the directive alone gave her. It was one given by the states.
The directive certainly didn't give her that. So you looked at the treaty. You'd say it's a treaty right.
Yes, but not the treaty without the intermediate intervention of the state by its domestic law grant. Maybe I should have argued the other way, but there we go. So that is what brings it. So essentially, the old scheme still operates. Turning then to the old scheme, I am. So if we turn up the eligibility regulations that are at page 295 of this bundle.
They're the ones that start at 279.
Yes. And if it's useful, we can certainly provide the court with the structure of those. They deal with both Part 7, homelessness, and Part 6, eligibility, in essentially identical terms, but in different regulations.
Yes, I see. You're trying to give us the title page. Yes, please.
Thank you.
Okay, but
Page 295.
sorry, I just want to understand what the base on which the judge proceeded. He says the effect of paragraph 5 is that it only operates to the benefit of people who would have had an enforceable right prior to 31st December 2020. Forcible right to what?
Reside.
Reside.
The immigration, the underpinning immigration status.
Yes. So, okay, well, perhaps it'll become clearer when we've seen this. Yeah.
Well, no, that is that turns on paragraph 5 of the legend.
No, I understand that. I'm just wondering how it was relevant then to look at these 2006 regs, which are regs made under the Housing Act, the Homelessness Act.
Well, I wanted to show the scheme to see the situation of those who are not persons subject to immigration control versus those who are persons subject to immigration control, which is the appellant's case, if that would be helpful. But
If you think,
well,
I don't know how your submission is going to go, but
short answer.
once Mr. Justice J, if Mr. Justice J is right, which you have to accept, though you don't agree, then we now know why she wasn't entitled to homelessness assistance simply because of the effect of 1852.
Well,
So isn't that all we need to know?
well, it might be. Court might want to see why she doesn't fall back, isn't brought back in within one.
Oh, I see. Okay.
So I can certainly do that by taking you to Regulation 5, which is at page 291. So this lists the people who are subject to immigration control but are nevertheless eligible. So this is an inclusory provision, and it lists a number of classes, and they are, in essence, classes of non-EU citizens who the government has decided as a matter of policy ought to get social assistance.
Yes, I see.
Refugees, people with exceptional leave to remain, people who have indefinite leave to remain and have been residing after a certain time, even though they gave an undertaking not to have recourse to public funds, that's C, D, humanitarian protection, and so on. She does not fall under any of those classes.
Yeah. Okay.
One of them relates to, just to complete this, one of them relates to people with PSS, it's J, and it's people who are family members of a relevant person of Northern Ireland, which is people born in Northern Ireland who are UK or Irish or both.
Well, unless you need to explain that to us, you better not.
And then Regulation 6, just for completeness, is also excludes some EU citizens who are persons subject to immigration control. And this is Belt and Brace's approach, as it were, to PSS. So we see at 6.1, the general rule, not subject to immigration control, but are treated as a person from abroad, so an exclusionary provision. And then the first category, which applies to everybody, is not habitually resident. So that's a factual question about intention to stay and length of residence. And that applies to that is a non-discriminatory test. It applies to everybody. And then B replicates Articles 14 and 6 of the directive. So this is what would have excluded the appellant if she'd claimed homelessness assistance during the first 3 months of her stay. She wouldn't have been able to rely upon her Article 6 right. She would have had to show more, even though she would for those 3 months not have been subject to immigration control.
So all these provisions, and again, one thing that confused me reading about this, although I thought these were 2006 regs, the relevant provisions are all inserted by post-Brexit legislation.
Not all of them.
All right. Oh,
Some of them.
well, I see.
So the one inserted by the A and B were there already. AB 1 and 2 were there already. 3 is inserted or is amended. But the new one is 1A. So
which regulation are you talking
Regulation
about?
6 1A towards the bottom of the page. Curiously, the Secretary, I think curiously, the Secretary of State felt the need to disregard, for the purpose of deciding whether a person has a right to reside, the existence of PSS. Now, I can see that maybe because otherwise the only right to reside phrase in B wouldn't catch the person. If the person would pop up and say, haha, I have PSS. So I'm not subject to immigration control, I'm a job seeker here, and I've got PSS, therefore I'm not excluded. So belt and braces needed to disregard that right. So this is the provision that operated against the appellant, would have operated for the first 3 months, but she didn't seek homelessness assistance for a year. So by the time she got there, she was a person subject to immigration control. Didn't.
Well, unless it's important to your argument, I think let's try and stick to what we're concerned with is the actual provision. The provision which is said to be unlawfully discriminatory is the one which actually produces the impact of which she complains.
Yes.
And that is 185. It's effectively 1852 coupled with the definition of PSIC and the unavailability to her of her being the provisions which might otherwise have deemed her not to be a PSIC.
Yes, it's 1852, on that analysis, it's 1852 plus paragraph 5 of the transitional provisions.
Yes, as interpreted by the judge. Yes, okay.
So
Thank you, that's been helpful.
good. Turning then to the text of Article 23.
Yeah.
If I could ask you, Your Lordship, to turn that up, which is at 144. Now, you have my submissions already on the text of 23.1, and you have my submissions on the operation of the text of 23.2 as regards a person whose where the conditions and limitations referred to in Article 6 or 14 have been waived, as they have been in, I say, in this case. What I say the Secretary of State is doing by the operation of the provisions that Your Lordship summarised at the end is introducing an additional derogation, which is that the host state shall not be obliged to confer entitlement to social assistance during periods of residence other than in compliance, other than in compliance with the conditions or limitations of Article 13.1.
Sorry, do you say these are words that should be read into
Yes,
derogation?
I'd say that this amounts to reading in a second or an additional derogation.
What's this? So give me the words that you said. I'm not quite sure.
So we had the first line, the host state shall not be obliged to confer entitlement to social assistance during periods of residence other than compliance with the conditions and limitations in Article 13.1. Or some similar form of words to defeat the waiver. The waiver doesn't apply to 23. We've waived it for your right to residence. You can stay under Article 13. You don't need to meet the limitations and conditions there to live here. But we're going to derogate from 23.1 by taking you out of it for social assistance only, because you don't meet the conditions of Article 13.1. So we give with the one hand the immigration, but then we get through to the welfare benefits second stage. We take back and say, doesn't extend that far. You are residing on the basis of the directive, on the basis of the agreement, but we're going to derogate.
Is this a necessary argument? Because if you're right that it's direct discrimination, then any derogation, then not granting housing assistance is a breach of the equal treatment in 23.1. however, it's only indirect discrimination and it is justified, then it's not a derogation. And so it's not in any way inconsistent with 23(2).
Well, it's a part. I put my case on direct discrimination in two ways. I put it on, secondly, on the traditional basis of analysing the textual scheme by and looking to see whether it makes a distinction that is inextricably linked to citizenship. But first of all, I say that under this scheme,
Okay, fine. I just wanted to see how the arguments fitted together.
you can, for example, you can affect many kinds of discrimination. You could have a 5-year residence requirement. EU citizens could say, hang on, that discriminates against me, but that's universally applied. But most importantly, it's not based on how I stand under Article 13. But what I say the state is doing here is they're adding another derogation in the withdrawal agreement. That's it. The gist of what they're saying is, when the withdrawal agreement made, we must have been able to grant people a right of residence under Article 13, if you're with me on issue 1, but nevertheless not be obliged by a right of equal treatment to grant them social assistance under Article 23. So it's not a justification argument for that on their part. It's prior to that. It's a derogation from 23. They say it's implicit in there. That's what I say the IMA is saying. It's implicit in 23. The person residing on the basis of this agreement cannot rely upon Article 23 in respect to social assistance unless they meet the conditions set out in Article 13(1), even though those conditions have been waived. And I say that's an additional derogation, and I say we can see clearly from the text of 23(2) that it's not there, and we can see that 23(2) has precisely enumerated two different kinds of benefit.
Yes, assuming the premise of your argument is right, there isn't much more you need to say, is there, about 23(2). It doesn't really come down to this, that it is perfectly clear from 23(2) that the premise is that there must be equal treatment as regards social assistance if someone is residing on the basis of the withdrawal agreement, and you've, by ex hypothesis, you won on round 1, and that's what the claimant was at the relevant time.
Yes.
And the only escape from that is derogation. And here are the derogations, and they don't include this one. So, end of story. Isn't that all you have to say?
Yes, well, what I want to say is that it's the kind of, it's the species of, it's the basis for the distinction, that it's a basis for distinction under Article 13. It's not located somewhere else, like residence, length of residence, or some other matter that might be indirectly or directly discriminatory. It's specifically under Article 13.
Yeah, I certainly don't want to close you down on this. There's more you have to say, but as time is limited, as I know, we're going to have to look at some rather complicated case law on the third limb of your argument. I wonder whether you need to develop this much further. It's your choice, but...
Yes, thank you. 421, can I just ask the court not to turn it up, but for your notes, to look at the text of the case of Crayfeld that I cite in my skeleton argument, and in particular, paragraph 60, but also to read on down to paragraph 69, which is what I would have wanted to take you to.
Well, I'm not saying don't take us to it. I was just offering you a steer. But if Crayfeld's important, we ought to see it.
Well, very good. So 421. It's tab 12. 41, starting paragraph. Well, actually, if we turn back to 420, we can see the heading above 56. It's whether Article 24(2), which you'll recall is the prior exclusion, derogation from the equal treatment provision in the directive, is applicable to union citizens who have a right to reside based on Article 10 of Regulation number 492/2011. Now,
Tell me what that regulation is.
that is the right to reside so long as you are the carer of a child of a worker where that child is remaining in education. My own friend Ms. Smythe referred to it in her submissions. So the court mentions at 57 Alimanovich, see in the Dano line of authority, and at 58, and then says at 59, the court's ruling was based on the premise that the National Court have found the persons concerned had the right of residence solely by virtue of being job seekers. In other words, their only right was this right under the directive. They did not give a ruling on a right outside the directive. As regards that situation, it must be recalled that the court has previously held on several occasions that a derogation from the principle of equal treatment is merely a specific impression, and then
Just to interpret strictly, yep.
various matters. 62, the second sentence, that provision is therefore explicitly stated to be a derogation from the principle of equal treatment laid down in Article 24(1) of that directive. However, that derogation is applicable only to persons who fall within the scope of Article 24(1). 64, they note that the codification by the directive was not exhaustive.
Just before, sorry, but rather than just throwing paragraphs at us, what is the proposition you get from this?
Well, from these passages, what I get is that even though you are residing on the basis of the directive, if you're also residing on the basis of another right granted under EU law or arising under EU law, then you're not caught by the derogation in 24(2).
How does that fit with the facts of our case?
Because we aren't residing under 24 of the directive, but it said that we should be treated with subject to the same limitations and conditions, but we are residing on the basis of Article 21 beyond the directive, which is essentially the same position as in Crefeld. So Crefeld wasn't caught, as we'll see at 69, I think probably the important passage here. While it's true that persons such as JD and his daughters fall within the scope of Article 24, including the derogation, on the ground they have a right of residence based on Article 44b, it can also rely on an independent right of residence, so that derogation cannot be used against them.
Yeah. Okay, well, I get the point. Yep.
And that supports an interpretation of the withdrawal agreement that keeps the derogation to the limit of the text of the derogation. So if I could just deal then with the three cases that have gone before, and I'm now at 107 of my skeleton.
We've gone before what, sorry?
So these are the cases that have dealt with factually similar situations that are relied upon against me.
So we're still on your impermissible derogation.
No, I'm so sorry, my lord. I'm moving on to the last point.
Oh, I see. Right. Okay, that's fine. Thank you. Yeah. So this is the point about this being indirect discrimination.
This is the point about it being direct discrimination.
All right, but whether it is indirect.
Sorry, I didn't hear you. Yes. So I want to clear out of the way these cases because they are Article 24 directive cases. They're not withdrawal agreement cases. And I don't think I need to go to them for that purpose. So just drawing your attention to what I say at my skeleton at 107.
Yep.
Patman Nice claim had no right to reside in the UK at all.
Hang on 1 second.
And that was, in my submission, essentially why she failed. Secretary of State's case was, I don't want her here, I can't remove her, but I don't want to have any benefits. It's quite different from, I'm happy to have her here, I've given her 5 years leave to remain. The immigration stage is different. CG, which you've seen extensively, was an EU law case. It was before the parties abolished the distinction between the directive and the wider treaty rights as regards both Article 13 and Article 23. So that's the crucial textual change that I need. I need a change of immigration, which we find in the grant of PSS, and I need a change of the text in Article 23.
I notice we've got to the end of your time.
I think, my lords,
What was the third case that you said?
the third case is Fratilla.
Bressol.
Sorry?
Which case? Bressol.
Fratilla.
Fratilla.
Facts were the same as in CG and the outcome was the same. The Supreme Court did not address the decision or the reasoning of the Court of Appeal. I think I'm afraid to take my submissions on the possibility that it can be justified, capable of justification, from my skeleton at pages 112.
Sorry, you keep using that formulation. Fine. I mean, I agree that's the ultimate question, but it is a question of whether this is indirect discrimination, isn't it?
In my
Or
submission,
is it
no,
not
in
quite
my
the same
submission
thing?
It's not. That's a label that is applied. The question under the law is the discrimination capable of justification?
But what distinguishes discrimination which is capable of justification from discrimination which isn't capable of justification?
Well, I say that there are at least two species of it when it's not capable of justification. One is where it's traditionally been labelled direct, in the sense that it's inextricably linked to nationality.
Okay, yes.
The other here is where it is based on an impermissible extension of a derogation.
Oh, I see. That's your point B. But
Those are my
yeah,
two.
okay, yes, I see. All right. Okay.
So are we are looking at whether it's direct or not?
On this point, we are looking at whether it's direct or not.
We would do it. Yes, that's my submissions.
And these three cases are about that.
I say they're not.
Oh.
I say, well, at least they're not sufficiently materially similar to require the same results.
Yeah, but I just want to get the ideas clear in my own head. I agree. The essential question is it capable of justification? You say no for two reasons. One, impermissible derogation, which we've looked at. But the other is that if there is discrimination, which you say it is direct, not indirect.
Yes.
And on that point, these three cases, that's what these three cases are about. They're all about the distinction between direct and indirect discrimination in the context of equal treatment under EU freedom of movement.
Yes.
And
So I say the distinction here is in my, just to go to my written skeleton arguments,
yeah,
that the reason it's direct here is that it's based on the criterion that the applicant must not be a person subject to immigration control.
yeah.
And that criterion cannot be failed by a British citizen. British citizen can never be subject to immigration control.
Okay.
And I say that is the crucial criterion is clear from the route that I discussed with your lordship from into 1852, as it were, by virtue of the transitional provisions.
Well, look, thank you. You have the comfort of knowing that Mr. Burton is to follow you, but not quite now, whatever time he was given, but you can fill in any lacuna in your, I don't mean that rudely, but you've been under time pressure. Yes, Mr. Burton.
My lords, my lady, the first piece of what I hope is good news for you is I'm not going to mention the withdrawal agreement again. The second piece of good news I hope I have for you is that the Secretary of State and I essentially agree, and I think Mr. Cox agrees too, as to how the domestic legislation works to exclude the appellant from eligibility for homelessness assistance.
Was my rather crude summary at the end of Mr. Cox's helpful?
Yes, and let me be absolutely clear, my submissions on behalf of the Air Centre, for which we're very grateful for the opportunity to make.
We say the key provision is section 185.
Sorry, I don't even know who you are.
I'm Mr. Cornwell.
Oh, sorry, Mr. Cornwell, how rude of me. Yes, right.
I'm from the Secretary of State.
Yes.
Just to be clear, before Mr. Burton gets started, we say that section 1851 is the key.
I see. Okay. Well,
So
we'll thank you. No, right. Enough said. There may not be the agreement you hoped for.
Okay, well, I was taking the description of the law, if I can put it that way, from the statement of Lorna Clare Fraser, paragraphs 33 to 50, which is in the core supplementary bundle, pages 156 to
Well, we don't like to
162.
look for law in a witness statement, but
No, I agree. Well, if I can help any further on that, paragraph 4 of our submissions, which begin at page 279, sets it out in sequence and explains.
I did notice this last night, and I found that helpful, though part of the problem is that no one on your side really agrees with the judge's analysis, so it makes it a little bit more.
I genuinely think it doesn't really matter for the purposes of my submissions. I've tried to incorporate that degree of ambiguity in how I present them. But my submissions are and do flow from the structure of the domestic provisions and how they exclude the appellant. And then I'll seek to try and distinguish the three cases that I say are important, which is Bressel, Patmonis, and Fertre. And so if it helps at all, I'm really following on from Mr. Cox's third.
Yes, well, that's most helpful because that's where he was most pressed for time. Thank you.
That explains why I'm not going to mention the withdrawal agreement at all.
Good.
I hope, and I am very conscious of the time I've got, that I'm not going to have to take you back to paragraph 4 of my submissions for the structure as such. But
I think we've got a sufficient understanding. It may all be unpicked when we hear Mr. Cornwell. No, sorry not to have recognised you straight away, Mr. Cornwell. I should have realised. It may be unpicked at that stage, but at the moment I think I understand how it works.
I may, if I have time, just say one comment about Mr. Cornwell's intervention a moment ago about the importance of section 185, subsection 1.
Yes.
But I'm certainly going to be interested in 2 and 3 in particular. And so if I can begin then just by setting out a couple of observations about how this scheme of eligibility, if we can put it that way, the sub-scheme of eligibility works. And the first is this, that the legislation is immediately concerned to separate and treat differently UK nationals from foreigners. At its apex, section 185, subsections 2 and 3, its first act is to divide one from the other. In contradistinction, and this becomes important when we look at the cases, from setting some overriding test, either legal or factual, such as physical presence, lawful residence, anything of that kind. The entry point, the apex, is UK national, foreigner. And that happens by the mechanism of persons subject to immigration control, which is, of course, people who require leave to enter or remain in the UK, whether or not they have it. So it's not seeking to distinguish lawfully present from unlawfully present, it's just foreigner, not foreigner, frankly.
But you basically say PSIC can, for all practical purposes, be defined as a foreigner.
And, of course, a non-PSIC as a UK national. From that initial separation, section 185 subsection 2, section 185 subsection 3, those two groups never meet again, are subjected to a discrete set of rules. The foreigner is out unless allowed back in by meeting a certain set of criteria, for example, refugee status, or, particularly in the context of EU nationals, meeting a set of burdens. Those burdens are reflected in enjoying an EU enforceable right to reside, but we all know what that means. It means to be a worker in some capability or a family member of such. And I'm going to just use that.
Sorry, you've been very clear, but I've just been rather slow noting. As you say, some foreigners are allowed back in for particular reasons. You mentioned refugee, and then you were saying something obviously important, which I didn't quite pick up about enforceable right to reside.
So EU nationals, the hurdle or the extra criteria they must meet to otherwise avoid the consequences of section 1852 all relate to, I'm going to use the euphemism of working or being economically active. We understand how all that comes about. The mechanisms for doing it is if they have an enforceable EU right to reside, they're not treated as somebody who requires leave to enter.
Just to make sure to myself I'm understanding, effectively you're saying there are people who under Article 7, so long as it remains enforceable here, satisfy one of the conditions in A to D under. Thank you.
And in other words, those who are not economically active remain to be treated as persons subject to immigration control, with a very small caveat about those entering in the first 3 months, which is dealt with slightly separately. But in broad terms, that's what we're left with. For the non-person subject to immigration control, principally UK nationals, it's true that some of them are then prevented from being eligible if they essentially fail a habitual residence test. And the only group likely to do that, again for practical purposes at the moment, are UK nationals who live abroad and have come back to the UK, and they need to demonstrate some factual connection to living in the UK before they can be eligible. So those are important observations, the structure of how this works, the immediate separation of the UK national from the foreigner. And just to reiterate the point, so I think there can be no doubt about this at all, despite what my learned friend, Part Secretary of State says, Section 1852 is the operable provision. That's the one knocking out the appellant. No doubt about it whatsoever. She's not let back in by any of the hoops or burdens. Pausing there for a moment, just to flag, the ambiguity between Secretary of State and the Air Centre is set out in our skeleton. It's about precisely how you reach that end conclusion. Do you read into the deeming provision to exclude those with PSS only, or do you do it by another mechanism? I'm not going to trouble you with it. It's in the skeleton if you want to see it. The consequence is clearly the same. That is quintessential direct discrimination based on nationality. It is not possible to accurately describe the reason why the appellant is not eligible without immediately referring to her nationality. It is intrinsic to the reason why she is excluded.
Well, I mean, you've gone straight to the heart of the matter. I see that, and that argument has appealed to a number of people, including Advocate General Sharpston, Lord Justice McComb, and lots of people. But it has not appealed to the Supreme Court.
My Lord, that is, with respect, correct.
No, good.
Would agree with that proposition I made a moment ago without hesitation.
Okay.
It's uncontroversial law that if you have a rule which allows everybody in on one side, the UK nationals, and excludes all but some of the other side, it's still directly discriminatory, because the reason I'm excluded...
I suppose you're right, but I mean, I'm not... You're saying it as if that's obvious, and I obviously see the argument that it's the case, but isn't the counter-argument that actually not all UK nationals get in? Because there's a habitual residence requirement for them. That I think I may be doing an injustice to Mr. Cornwell's argument, but that's certainly the argument in Pat Munley's.
My Lord, I am absolutely going to deal with that argument.
Okay, fine.
Okay. I'm just going through the stages because I think it's important. And if I may do it that way, I hope I'll get to the end point that you need me to get to.
No, that's fine. I won't hold you up. You know what you're doing.
Conceptually, it is very important in my submission to understand that this would ordinarily, I understand that's a loaded term in this context, be treated as direct discrimination on conventional application of principles. And it only ceases to be by reference to an approach to the scheme as a whole, which the Secretary of State says you are bound to follow, which requires you to essentially treat Ms. Fertre's nationality as incidental to the reason why she's been treated differently from a British national. In other words, as a form of indirect discrimination, where her nationality just so happens to be part of the mix as to why she's excluded. Now, I'm going to deal with the cases which the Secretary of State says, and Mr. Justice Jay was persuaded did bind the court to take that approach. But I do think it's important to say at the outset it's a deeply counterintuitive one, and it's one that Mr. Justice Swift describes in the last of the three cases I'll take you to as one requiring a process of intellectual contortion, and he is absolutely right to describe it that way. The heirs submission fundamentally is this one, that you are not bound to engage in that intellectual contortion, because the structure and manner in which the discrimination arises here is qualitatively different from the manner in which it arose in the three cases I'm going to take you to, for two principal ways.
I'm sorry, this is all good stuff, but I therefore have to write it down. Yep, two reasons.
In both the principal cases against me on this, Bressel and Pat Marlies, the directly discriminatory rule was, to use the language of Lord Hope in the latter case, subsumed by an indirect residency test or indirect rule, such that a composite approach required the court to treat the case with one indirect discrimination pursuant to Bressel. That is not the case with section 1852. It is not subsumed by any other test, whether that test be an indirectly discriminatory one or otherwise. It is not subservient to a broader test of residence, habitual residence, lawful residents, anything of that kind. It's straight at its apex discriminatory. If that's not persuasive, the second alternative, and they can be both correct simultaneously, is that if you don't look at this case from the top, but you look at it from the bottom, then there is a very specific carve-out for those who have pre-settled status only. A group which, again, is being discriminated against directly because it is solely made up of EU nationals. No UK national can get into that group. And they are treated differently from UK nationals. And it matters not that not every EU national is included within that group. It's still nationality-based direct discrimination. And Fertre, majority, Court of Appeal, albeit it's now obiter because of what's happened in the law, which is unconnected to this point, found that because it was done in that way, that structure took it outside the Pat-Marnie-Espresso categorisation. So that's what I'm going to say, and I'm going to now try and make that good.
You've done it so clearly that you can take the cases very shortly. You're going to have to.
Very well. If I can just do it this way then. Tab 24, Bressel.
Yeah.
Please first, can we look at the rule? And that's at paragraphs 8 and 9, page 828, authorities bundle.
Just one moment, sorry. So I may be being unkind to you. What time were you given Monday or under your
Well,
deal?
originally 35, then 25, now 20. And I did hope in those 20 I wouldn't have to say anything about the actual go back to the scheme at all, which
No, that's fine. I just wondered whether I was being too strict with you, but I think the answer is I wasn't being too strict with you, but keep going. We'll manage.
My learned friend on Party Secretary is going to take you to these cases. That's guaranteed. And I just need a short while to make my points.
You go ahead. You go ahead.
So Bressel is where this problem starts, the intellectual contortion as so described.
Yep.
The rule itself that was being scrutinised is at paragraphs 8 and 9. It was a rule about distinguishing resident students in Belgium from non-resident students. And it is clear as day in the first outset a residence requirement, which of course is not inherently directly discriminatory, contradistinction to our case, which then had a set of sub-criteria that also had to be met. The first of which you see there in paragraph 9, he has the right to remain permanently in Belgium, was one that operated in this way, that a Belgian national automatically had that right, but a non-Belgian national had to work hard to get it, had to go through the burdens, and we see that at the caveat at the end of the rule. Do you see the words, the right to remain permanently within the meaning of paragraph 1.1 means for citizens of other member states, etc.
Yeah.
What did the European Court say about that? Paragraphs 45 and 46, page 833. A residence condition, such as that required by that legislation, which is the entire rule, is more easily satisfied by Belgian nationals who more often than not reside in Belgium than by nationals of other member states whose residence is generally in a member state other than Belgium. It follows, therefore, that that's a form of indirect discrimination and it's capable of being justified. So what the European Court did is looked at that entire rule that we just looked at a moment ago in paragraph 9 and said, well, this is basically a residence requirement. That's an indirect one. We don't need to trouble ourselves with the sub-rules. Where does the controversy arise? If we could just look very quickly at the Advocate General's opinion, paragraph 66, which is at page 809.
Yeah.
Now this is
Sorry, page number?
809, my lady.
09.
Now this is important. This is where the Advocate General analyses the second condition, that was condition 1, residing permanently in Belgium, and analyses it on the basis that a Belgian national qualifies automatically, a non-Belgian national has to go through hoops. And that analysis, according to the Advocate General, gives rise to direct discrimination.
Yeah.
Irrespective of the fact that, of course, some non-Belgian nationals can go through those hoops. That's not the same thing as saying the residency test generally was a test of direct discrimination. Now, it's true to say that the Advocate General says, well, because of the direct discriminatory nature of the sub-rule, I'm going to treat the whole set of rules as being direct discrimination. The court doesn't accept that, but it doesn't disagree with this logic. And that's the important point I want to convey. Because what we'll see is that's what the English case law also says. If you have a rule such as this, where all UK nationals pass it, but only some member state nationals can pass it because they have to do extra burdens, then that's still a directly discriminatory rule. And that is an uncontroversial statement of law, but an important one. So that's where we end up with Bressel. If we can then come to Pat Marnice, which is tab 54, and look at paragraphs 7 to 9 to see what the test was there.
Sorry, what tab was that?
Sorry, my lady, that's tab 54, beginning page 1819.
I'm sure it isn't really pronounced Pat Marnice, but since none of us speak whatever the language is, that's what we all call it.
Is it Nietzsche? I don't know.
I suspect. No, let's call it Pat Marnice. Yep.
So the rule we're looking at here, you can see described in paragraphs 6 and 7 and 8.
Page.
1824, my lady. So the headline provision, the apex provision, is section 1.2a of the Welfare Reform Act. This is about entitlement to pension credit. And you don't get pension credit unless you are in Great Britain. Straightforward residency test, clearly on its face, immediately one which would be described as being potentially indirectly discriminatory, but certainly not directly discriminatory, because foreign nationals and UK nationals alike might be in Great Britain. Then there's a regulation which helps inform what being in Great Britain means, which is the subject of it is set out in paragraph 7. And it's a habitual residence test. Again, an indirectly discriminatory rule, capable of being met by both parties, even if it might have a slightly, it might be harder to meet for a foreign national than a UK national.
Yep.
People were not to be treated as not habitually resident if exercising EU treaty rights. We see that in subsection 1. And then subsection 2 is that you can't be habitually resident if you don't have a lawful right to reside. Do you see that? Subsection 2.
Yeah.
The relevance of that is that subsection 2, in a way at the end of the regulation, that was the subject of the challenge. Lord Hope gave the lead judgment. Paragraph 25 onwards, beginning 1830. Paragraph 25, Lord Hope explains those stages, in Great Britain first, habitual residence next, explains that both of those are indirectly discriminatory rules, or potentially indirectly discriminatory, but certainly not directly discriminatory. Says that then nationality starts to become an issue when you look at some of the sub-rules there, and in particular, at paragraph 26, goes on to consider regulation 2, subsection 2, which is that you can't be habitually resident unless lawfully resident. And goes on to explain at paragraph 26 that that would be a directly discriminatory rule if looked at in isolation. So entirely consistent with the Advocate General's analysis in Bressel.
Yeah.
But then at paragraph 27, Lord Hope says, but you don't look at it in isolation in this kind of case. You have to start with where you start, which is in Great Britain, which of course is an indirectly discriminatory rule that everybody must meet. Then at paragraph 30, he explains that that's the approach taken by Russell.
Where does he use the language of subsumed? Or we're coming to that, are we?
Coming on to that, paragraph 34, my lord.
Okay. You're going to have to take this very shortly, I'm afraid, but you're doing no, absolutely.
Paragraph 30, you'll see where the first point to make is Lord Hope identifies the very clear similarities between the rule they were looking at and the rule that was being considered in Bressel.
Yeah.
And then at 34 is where we see that the key words, the second cumulative condition as to the right to remain permanently in Belgium, which the Advocate General said was necessarily linked to a characteristic indissociable from nationality and directly discriminatory, was subsumed into the first when the two conditions were treated cumulatively. And then again, just to hammer home the point of paragraph 35, there is an obvious similarity between the provisions they were looking at and the ones under consideration in Bressel. That similarity does not exist in this case, my lords and my lady.
Yeah.
Can I then take you finally to Fertre?
Yeah.
Tab 47. If I could ask you first to look at the rule they were looking at, it's 1555.
What's the tab number again? Give it to me.
Apologies, my lady. Tab 47. 47.
Yeah.
And then we're going to page 1555, which is actually the appendix, but just so we can see the rule.
1555.
Two observations about this rule, which are important. It is essentially identical to the rule being looked at in Pat Monteith, subject to one very important caveat, which is the carve-out for people with PSS. Which you'll see at regulation 93C1, page 1556. Do you see that? Person having been granted limited leave to enter or remain in the United Kingdom under the Immigration Act 1971 by virtue of Appendix EU to immigration rules made under Section 3.2 of the Act. So that's what was under consideration here. And as we know, the majority of the Court of Appeal found that Pat Monteith could be distinguished.
Yeah.
Did so on two bases. This is important. I don't want there to be any confusion that I'm relying on something I can't rely on. The first was, keeping in mind that this was pre-GC, CG, very grateful. This is a situation where, pre that case, it was still the case that if you were relying on free movement rights in a particular context, then the question of justification just didn't arise. Any form of discrimination was unlawful. And the court found that that applied here. But also found, in my submission, that the nature, the structure of the provision now was different. And because of this individual carve-out, which of course exactly what we have here, looked at from the bottom up, the approach to Pat Monteith didn't apply. So I'll take you first to Lord Justice McComb, if I may. I'm going to just headline this as much as I can. Paragraph 58, first point he says, is that much of the difficulties in this case falls away once you realise this is a different case from Pat Monteith. Paragraph 60 is where he introduces the Trajani line of cases, which was the point I mentioned a moment ago, which I do not rely on, but was one of the reasons why he said Pat Monteith was different. Paragraph 61, the Learned Lord Justice makes the point that Mr. Cox made, that the principal difference here was in Pat Monteith, it was a complaint about a right to reside test from somebody who had no right to reside, whereas here the complaint was somebody who had a right to reside, but it was of a type that had been carved out. And it was of a type that was directed towards a certain group, those with PSS only, and therefore, as such, should be considered directly discriminatory in a way that couldn't be avoided by looking at the tests in some kind of cumulative way. I would commend, if I may say so, but I'm not going to take you through it now, paragraphs 62 and 63 for how Lord Justice McComb described the decision in Pat Monteith and Bressel and how they interrelated.
Yeah.
And then it paragraph 65, referencing submissions made by Mr. Delamere, QC, who then was about the importance of the carve-out.
Yeah.
Paragraph 66. This point's to some extent impressionistic, but it's very important in my view. Mr. Delamere said, okay, let's imagine this wasn't a residency or a nationality right. Let's imagine it was a different type of direct discrimination. Let's say it was carving out something for people of particular races or sexes. We wouldn't be balking at this idea. We would find it inconceivable. We could look at it as anything other than direct discrimination.
Got it.
To be absolutely clear, 68 and 69, on behalf of the Secretary of State, Sir James Eadie said, no, this is normal. It's Bressel. This is still just looking at a composite test, and that is then rejected by Lord Justice McComb. And the paragraph in particular I wanted to take you to, thank you, is paragraph 74. Which is, if I can take this very briefly, where he reflects the fact it's carve out. He reflects the fact that if you were to look at it on any other impermissible ground of discrimination, you'd see it's such.
Got the point.
And then the critical last point, if I can just really get this home, is the coal point. It doesn't matter that it doesn't affect everybody.
Yeah.
As I said, that's an uncontroversial point of law. Coal's in your bundle. If you
I
like to see
don't
where
think
it
that
comes
point's
from.
been taken, but if it is, we'll hear.
I'm very nearly done now, but I do also would like to take you to the concurring opinion of Lord Justice Moylan, and I can take this very quickly.
Well, do you really need to? I mean, we will of course read it, but he effectively says the same as Lord Justice McComb, doesn't he?
Yeah, but I would suggest that he does it in a slightly clearer way.
Okay, show us the paragraph that's slightly clearer.
Paragraphs 94.
Yeah.
He says basically they weren't dealing with provisions that overtly targeted, in Bressel that is, non-Belgian nationals. And he says the same thing about the right to reside test in Appellant East. Paragraph 96, 97 and 98 are the meat of it. And I would invite you to adopt all of that analysis in respect of this case. And you can do that even if you're not with me on the first point about the apex and where we start.
Yes.
Even if you don't take the structural point, you can do it just on this point. Of course, it's correct to say, my learned friend's going to tell you, Lord Justice Dingemans, am I pronouncing that correctly?
You are pronouncing that correctly.
Took a different view.
I only standing up for Lord Justice McComb because I know he felt strongly about it.
Well, I'm very sorry to Lord Justice McComb for that.
But no, you are, well, I think really, I'll have to call a halt. There's been a masterpiece of
Can I make
compression.
one final point? I promise this is my
Right,
last one.
yes, you can.
Lord Justice Dingemans is in the minority, but it's a minority opinion that my learned friends are going to rely on. It's wrong, if I may respectfully say so,
Yes.
for precisely this reason. He again adopts this approach that unless the exclusionary rule excludes the entire group, it's not directly discriminatory. Contrary to Cole, contrary to Lord Justice McComb, contrary to Lord Hope in Pat Moniz, contrary to the Advocate General.
Bressel. Yep.
Final point. Please don't let the tail wag the dog here. We know what the consequences are of this being treated as direct as opposed to indirect discrimination, but that cannot distort the process. Otherwise, we're engaging in a double.
We won't do that. We're intellectually rigorous, Mr. Burton.
Well, indeed, that's true. I just had to make sure I made that point. So unless I can assist.
Well, if I may say so, a masterpiece of compression. Thank you very much indeed. Mr. Cromwell, you lost a bit of time. We'll make it up to you somehow if you need it. But at least we have been taken to those cases, so that may make the task a bit quicker. But off you go.
Sorry, let me sort of use. My lord, lady, as you would have discerned, the Secretary of State's position it is on the second issue, which is one that only arises if we lose on issue one. that we say that this is any discrimination here is indirect in nature, or if you prefer to use Mr. Cox's label, is capable of discrimination.
Yes,
sure
no,
it's
we know
actually
that's your
any
position. Yeah.
material difference. So the key point is we say that properly analysed, both looking at the case law and the actual scheme in issue here, this is a case where any discrimination would be justified.
Yes.
I'm going to make my submissions in 4 stages. First, I'm going to make some very brief introductory remarks. Second, I'm then going to look at the domestic legislation. I'm afraid I am going to have to unpick it a little
No,
bit.
that's fine. I hope.
Because I don't entirely agree with the
No,
emphasis
good.
placed on
Well,
it.
don't trail. Just why don't you just go straight to the point? So,
And then-
one introductory remarks. You
Well,
tell us.
Two
Yeah.
one line further trades. My third point, I'm going to then look at case law. Fourth, I'll then tie the ends together and address any remaining points from the other party submissions. So first, my introductory vision. We say, first point we say is that the judge's analysis of this issue at paragraphs 98 to 107 of the judgment, I won't take you to those, but they're for your note, they're at 51 to 53 of the core bundle. We say that they are correct and that they should be upheld. The second point I made is that in my submission, it is relevant even to considering the question of what the nature of the discrimination is, not just the question of whether it's justified, to look at the prior position under EU law that my learned friend Ms. Smythe Casey took you through yesterday. The clear position that had been reached under EU law by the end of the transition period was that you had to be exercising rights under the CRD unless you fell into one of the exceptional cases where you could rely directly on the treaty. And as Ms. Smythe said yesterday, that's not something that's collective could rely on. There was no protection at all from equal treatment, in respect of equal treatment, under Article 24(1) of the directive. It's not the case there was a derogation, it's not the case there was justified indirect discrimination, there's simply no protection, you don't fall within scope of it. And in my submission, that is relevant background to considering the arguments that are being advanced by the appellant in this case, that we would move from a situation where someone in Ms. Fertre's position would simply have no protection at all, to one in which doing precisely the same thing, i.e. withholding entitlement to social assistance, becomes something that is not only discriminatory, but is indirectly and necessarily unjustifiably discriminatory. My third introductory point is that it's important to remember the underlying position. Although the cases we're going to look at refer to someone not having a right to reside, the key point is that someone didn't have a right to reside under EU law because they were economically inactive and not self-sufficient and hadn't resided lawfully for 5 years in the host member state. That's what we actually mean, and that is what the post-Brexit position, we say, quite lawfully, is in respect to the homelessness assistance. Although a person has a domestic law right of residence, and if your lordships and your lady find that actually that somehow, by some means, is a right of residence such as to engage Article 23(1) under the Withdrawal Agreement, it is still the case that the policy objective that is reflected in the consistent body of EU law must be taken to recognise the particular position of those who are economically inactive and not self-sufficient vis-à-vis the host state. Final point to note is, as Mr. Cox said, that the positions in relation to eligibility are essentially the same in respect of housing allocation under Part 6 of the Housing Act. But obviously the focus here is on the homelessness provisions under Part 7. That brings me on to my second topic, and the first of the substantive topics.
Yes.
My Lord, I crave the Court's forgiveness for reciting the law in the witness statement of Ms. Fraser, but it seems to be important to actually tee up when we're preparing.
Well, you can always adopt it as part of your submissions. That was it. Wasn't being serious.
We do so, but it's important to tee up the argument, the evidence on justification, the policy rationale.
Well, hang on. Sorry, we're not on that.
No,
I thought you were going to say where you disagreed with the analysis we got from Mr. Cox about why.
yes. If I may, I will take you reasonably quickly, I hope, through that and show why he is looking at the wrong target.
Yes, no, that would be very helpful. I wanted that all along. So we presumably go to the Housing Act first.
Yes, if we go to page 22 of the authorities bundle.
Yeah. Yep.
As you will see, my Lord, it's explained in more detail in the general explanation of the statutory scheme in Ms. Fraser's witness statement. But if one takes a step back from section 185, there is a series of successive duties. Each, save for a duty to provide advice, all of those duties require someone to be eligible.
Sorry, I've got lost. A series of successive duties.
Yes,
What are the duties?
There's an interim duty to accommodate.
Oh,
I was on page 22.
That's on page 26. And then there's
sorry, you've lost. I'm glad you've lost my lady as well. I thought we were analysing.
yeah, I just want to contextualise before I move back to section 185.
But what the duties are under Part 7.
I don't want to.
Well,
given the time, I'm not going to go into that in detail. I just make the point.
Mm-hmm.
And I'm going to take the interim duty at 188 as an example, which is at page 26 of the authorities bundle. You will see, my Lord, that the conditions in subsection 1 there, if local housing authority have reason to believe an applicant may be homeless, eligible for assistance and have priority need, then a duty kicks in. And that formulation in respect of being eligible for assistance is then repeated in respect to the subsequent duties.
Yes.
So that is where...
So everything depends on eligibility for assistance.
Yes.
There isn't a section which adds such. What's this? As a matter of we'll be looking at provisions about ineligibility.
Yes.
Where are the provisions about eligibility?
Well, someone is eligible if they are not ineligible. And so structure...
And I'm fine, that's a perfectly sensible way of doing it, I suppose, but where does it say that?
I think that is implicit in the approach the Act takes.
I'm not saying you're wrong, but you've drawn your I can't believe that when you look at 188 interim duty, it'd be the same for 189 and the other duties.
Can I take you back to move on to 185, which gives you the answer, my Lord.
All right, okay.
So if we go back to page 202.
Yes.
Heading entitled persons from abroad not eligible for housing assistance.
Just before you go there, what about 183 subsection 2?
Yes.
Sorry, my Lord. Yes.
That's my answer.
Yes, that is the answer, and then we find the explication of that answer at 185.
Okay, well, don't worry about that. Sorry, I just want to make a note of that. So
Yes.
you very sensibly pointed out that eligibility You're referencing us to 189 simply to make the point that eligibility for assistance is a key concept.
It's a key concept.
And it's, as my lord has helpfully reminded us, it's defined in
It's defined.
189.
I'm very, very grateful to my lord.
And it means, just as you said, it means anyone who isn't excluded by 185 and 186.
Yes. So that we then look to 185, and in my submission, the key provision here is section 185.1, which sets out the measure that is actually being complained of in this case. A person is not eligible for assistance under this Act if he is a person from abroad who is ineligible for housing assistance. Ms. Fertre's complaint is that she has fallen foul of that. Now, the reasons why someone may fall foul of that provision are then found in a complex web of composite provisions, but that, in my submission, is the relevant measure.
Well, that is what I put to Mr. Cox, but I must have looked at this section 100. Well, no, perhaps not this particular section. But in fact, the relationship to the two subsections isn't obvious. It doesn't say a person is not eligible for assistance in the following circumstances, and then you have a series of particular grounds on which they're ineligible. It appears to be a freestanding objection. But then what is...
No, it's
well,
we have.
It has to be from abroad. That's right. It's not a defined term.
No, it's not. It's not a. It means someone who's come into the UK from somewhere else. So that can be a UK citizen returning to the UK, or it can be someone citizen of a foreign country coming to the UK. But the point is someone entering the UK. Well, look,
Well, why entering the UK? I mean, you might be asking for housing assistance 5 years after you've entered, or 6 months after you've entered, or...
Well, the test is still applied.
So if I've lived in America for 10 years and come back to England, and after 5 years I'm ineligible from housing assistance, clearly I'm not a person from abroad.
No, but you
just because I've once lived there.
You would in any event satisfy the habitual residence.
Yes, I see. Okay, well, let's not waste my fault for raising a point on that.
In my submission, my lord, that is the key provision, because it says who is not eligible.
But it says a person is not eligible who is ineligible.
Yes,
I mean that.
But then it then goes on to explain how you can be ineligible for housing assistance. First basis on which that you can be ineligible for housing assistance is if you're a person subject to immigration control as defined in the 96 Asylum and Immigration Act, and is not covered by one of the various accepting regulations. And then the second route, we don't need to worry about 2A present purposes. The second route is that persons who are not other persons, i.e. persons who are not subject to immigration control, can fall into excluded categories, be rendered ineligible.
But just coming back to the structures of 1 and 2, because obviously you attach importance to it, and you may... you say that the essential operative provision is 1.
Yes.
And 2 is simply one of the kinds of people who is ineligible for housing assistance, which is the final words of 1.
Yes, red.
That's the structure. But 1 wouldn't work without 2, because if you just looked at 1, you wouldn't know who was ineligible for housing assistance.
It also wouldn't work without 3 either, because that is the converse of expanding the category of ineligible people from those who are persons subject to immigration control. So I say there's a single, the relevant measure that's being imposed here is 1851, and then one has to look at these two routes, which themselves then fork into.
Okay, I see how you put that. Well, you'll come to why that ultimately makes a difference, given that 1852 is also needed.
I will flag it now. I say it makes a fundamental difference because it places this case precisely back in the Bressel Appellant niece category, where you have a rule 1, which is indirectly discriminatory.
But Rule 1 has no content unless you have defined ineligibility for housing. It's not a rule. It's only a rule if read with 2 or 1 of the other bits.
It's a whole package. I mean, you've got. I mean, either you take it as my primary solution is, you take it as itself a rule, or to the extent that it lacks content, it has to be taken in tandem with the whole of the rest of the package, which one finds in subsection 2, subsection 3, and the relevant provisions of the 2006 eligibility regulations.
It would have been more clearly drafted
Yes.
if 2 said is ineligible, because that would involve some of the circularity is apparent. We said a person is not eligible for assistance under this person who's ineligible. A person is ineligible if he's subject to immigration control. But never mind. I see how you're putting it. Thank you.
So that is.
Thank you.
That's section 185, which is the core, and that is how I say that section should be read.
And just because time is short, I now understand why you attach importance to the very beginning of this exercise. But are all the other stages in the exercise correctly identified by in the exercise we do to Mr.
Broadly,
Cox?
but I want to point out
Right.
a couple of further steps. The key point in relation is it's important to appreciate the position of EU citizens before the end of the transition period. An EU citizen could be someone who was a PC, even at that point, a person subject to immigration control. Section 7.1 of the Immigration Act of 1988 deemed an EU citizen who was, or someone who was exercising enforceable, who was entitled to enter and remain in the UK due to enforceable EU law rights or provisions under Section 2.2 of the European Communities Act, they were deemed not to be, they don't require leave to enter or remain, and therefore not a P6 for purposes of Section 13. But if you're not exercising enforceable, if you're not exercising enforceable EU law right, you would still be a PC.
Yeah, we've got that point. So it's effective if they're not workers or students or trying to be workers and all those other headings. Yeah, got that.
So one then needs to look at the regulation, having set up the starting point, which I say starts with one provision and then forks to 2. Under each of those, one then has the regulations. If you turn to the 2006 eligibility regulations, which are at tab 7, tab 7 of the authorities bundle, and start at page 279. The relevant provisions for our purposes are Regulation 5 at page 291.
Hang on 1 second. Yes.
That is the provision, that is the regulation that is made under Section 185.2 and brings back in certain persons, categories of persons subject to immigration control who are in fact eligible. That can cover EU or EEA citizens, and in particular I draw the court's attention to paragraph 1C, class C. A person who is habitually resident in the United Kingdom, Channel Isles, Isle of Man, etc., and whose leave to enter or remain in the United Kingdom is not subject to limitation or condition. So that's somebody who has indefinite leave to remain, as the court is aware, settled status under the US is a form of indefinite leave to remain.
Just to be, I thought, have I misunderstood the definition of being? I thought if you had indefinite leave to remain, you weren't a P6. I got that wrong.
You are a P6.
Yes, I see. Sorry. Okay.
But for these purposes, so that's how you get.
You say for these purposes, but this is bringing people. This is bringing people back in who would have been excluded by 2. I'm just wondering if you were people with indefinite leave to remain weren't excluded by 2 in the first place, were they? Because they weren't P6.
Yes, no, because they're a person who requires leave to enter.
I see. It's my fault. I've misunderstood. Yeah, okay, now keep going.
So they would have leave to enter or remain in the form of indefinite leave. And
yes, okay. I was wrong. Sorry.
Post-transition period, someone with settled status, or indeed pre-transition, if someone had settled status under the US, they would have indefinite leave to remain, and that is how they would be eligible for homelessness assistance. We then move to Regulation 6, which is at page 295. And that is the provision that renders some people who are not persons subject to immigration control ineligible for housing assistance when read with section 1853, which it is made under. And you see that and one sees that various, as my learned friend pointed out, there is at Regulation 6.1b, sorry, 6.1a, there is a habitual residence requirement. You are deemed to be ineligible even if you're a UK citizen, if you're not habitually resident. There is also an exclusion for rights to reside as job seekers and in the first 3 months of residence for EEA and EU nationals. And this regulation needs to be then read with definitions which refer back to the EEA regulations 2016 of concepts like job seeker and so on.
And why was that still in force in 2021?
Because, well, perhaps we'll come to that in a moment.
Okay.
In the way that saving provisions work. But this is, we say, how what are genuinely derogations under Article 23.2 of the Withdrawal Agreement work in respect of the housing assistance of post-Brexit. But I'll come back to that in a minute. We then have a provision which my learned friend Mr. Cox said was curious, which is a provision requiring pre-settled status.
So sorry, which provision are you referring to?
1A,
1A,
at the bottom of page 295. That is a provision which does exclude those with pre-settled status. It excludes pre-settled status as a relevant right to reside, but purely for the purposes of the way in which Regulation 1B works. Because the problem was that when the pre-settled status was introduced, it could be said that someone could say, "Oh, I have a right to reside on the basis of pre-settled status, and I'm a job seeker," and therefore the definition wouldn't work. So that
Sorry,
this,
do we need to know this?
we don't. My learned friend suggested it was curious, but I think we can skip that.
Okay.
And then critically, importantly, I take you to regulation 2, paragraph 2, which is over the page. The following are not to be treated as persons abroad who are ineligible for housing assistance pursuant to paragraph 1A, that's the habitual residence provision. And then we see a number of concepts from EU law as applied by the EEA regulations adopted. So workers, self-employed persons, and various forms of, and then person who's a qualified worker under regulation 6.1. That's someone who retained worker status pursuant to Article 7.3 of the directive. And then family members of such persons, persons with a permanent right
Well,
of
we can see what
residence.
it says. What's the point you're trying to make?
The point I'm making is that these are people who are, in a sense, in a better position than the UK resident because they don't actually need to show, provided they qualify for one of those categories of qualified person, they don't even need to show that they're habitually resident. So, my lord, that's the position as it obtained prior to the end of the transition period.
Oh, I thought this was the
Well,
regulation just showing up post the end of the
And
transition.
we say, and Mr. Justice Jay accepted, that is also the position as it obtained after the transition period. My learned friend Mr. Cox broadly, I think, correctly identified the route by which that saving takes place.
Well, let's not spend time on it. By the end of his submissions, I thought I understood it, and if you
Yes.
think he got it right, I think we only got limited time. I wouldn't spend any more time on it.
So the key point is that the saving is only in relation to those who have pre-settled status. And because of the saving of section 7.1 of the Immigration Act 1988, someone with pre-settled status can only benefit from that saving if they would have had an enforceable EU law right.
Yeah. So that's the law as on the basis of which we are proceeding on this appeal,
That's right. And again,
despite Mr. Burton and Mr. Cox thinking it's wrong.
yes.
Yeah.
I won't.
No, that's fine.
So that is how the position is maintained. If one can summarise the position that one gets to now under section 185, post the end of the transition period.
I'm sorry to be brutal, Mr. Crawley. Do you need to summarise? You've got there, haven't you?
I
And we
think-
need to look at the case law.
Yes.
I mean, if it's something important, of course, make the point. But if it's just summarising, we've done it.
I'm grateful, Mother, but as I say, I have adopted the relevant passages, paragraphs 33 to 51 of Ms. Fraser's.
Yes, thank you.
That sets it out sets matters out in slightly more broad detail.
We will have a look at that.
But I do want to draw the court's attention to features that flowed from that analysis. And this is again focusing on the post-transition period situation. First point is that anyone, regardless of their nationality or citizenship, can in principle fall within section 1851 and be a person from abroad who is ineligible for housing assistance. That includes a UK citizen who may fail the habitual residence test and therefore be deemed ineligible under section 1853. Second point is that many EU citizens will not be persons from abroad who are ineligible for housing assistance under section 1851. and that will either be because they are deemed to be eligible, they're persons subject to
Did you
immigration
say many
control,
UK, many EU citizens or many?
EU citizens,
Yes, I see. Sorry,
or EA.
I may have
Point-
misheard. Yep.
point
Okay.
is-
Many EU citizens will not fall under. Yep.
And that will either be because they are persons subject to immigration control who are deemed to be eligible under regulations made under section 1852, and that will particularly be the case of those who have been granted settled status, or because they are not deemed not to be persons subject to immigration control because they are persons who would have had an enforceable EU law right to reside, i.e. e.g. workers, self-employed persons and so on. Third point, indeed many EU citizens will, unlike UK nationals, be exempt from needing to show factual habitual residence under Regulation 6(1)(a). And that's because they are workers, self-employed, etc. And that group will include persons with pre-settled status. In fact, that group will consist of persons with pre-settled status because of the way that the savings work.
Can I just be clear about that? That's the last point you made when we were looking at the regs. Your point is that people in this protected status or this special status are better off than EU citizens, than UK citizens who have to show habitual residence. But anyone, by definition, this group of EU citizens you're talking about will also be able to show habitual residence, because otherwise they won't qualify for any of those heads which are identified. Be very.
Not necessarily.
Oh, I see.
Because if one arrived in the UK and subject to the point that if one arrives in the UK and starts working and qualifies with a substantial job with with long-term prospects, one will fairly quickly one would easily satisfy the test of being a worker. It may not be the case that you would necessarily satisfy the test for habitual residence if you'd only been here for a very short time. So yes, I do say that is a.
You stick to your point, guns on that. Okay.
So I stick to my point that I mean it may not be, actually speaking, there may not be many cases where there is a difference, but it is conceptually it is a point of difference.
I mean, take family member. You don't have to be habitually resident to be a family member qualifying, do you?
No, if you are if you're a family member of a worker or a self-employed person, so on, then you also gain the benefit of
On day one.
under Regulation 6. Yeah, I mean, from the point that you would be judged, or your sponsoring family member, as it were, is deemed to be a worker. And then the final key point I want to make, and I'll come back to this as we go through the cases, is that in my submission, particularly Mr. Burton's submissions, are a triumph of formalism over substance. There are obviously differences in the drafting technique that were adopted by those who drafted Section 185 of the 96 Housing Act, as compared with the various social security regulations that are looked at in the cases. But in my submission, that shouldn't distract the court from the underlying substantive similarity, which is arriving at the same point, that the same people will end up being entitled to social assistance in the form of housing assistance, of course, be eligible for housing assistance. Obviously, they may not satisfy other conditions, but they will be eligible, as are eligible for social assistance welfare benefits, and the same people will be excluded. The particular way in which section 185 is structured, which is not structured by reference to being in GB, in Great Britain, shouldn't distract from that. So, my lords and my lady, I've moved to my third topic, which is the case law.
Yes.
I agree, the starting point is Bressel. My learned friend, Mr. Burton, took you through some of the relevant provisions of that judgment. The test in my submission that perhaps set out the domestic test that was under challenge in this case, which is set out in paragraph 9, that's page 828 of tab 7 of the authorities. No, tab 24 of the authorities bundle. Is a complex composite test. The court had the opportunity to adopt the reasoning of Advocate General Sharpstone, which my learned friend Mr. Burton took you to, but it quite clearly decided not to, and we can see that from the analysis at paragraphs 40 to 46. While we're there, I just want to refer your lordships and your ladies to paragraphs 40 to 41, which I will pick up on when responding to Mr. Cox's points about derogation, where it is explained by the court, this is at 833, it is explained by what the prohibition on discrimination means. It means prohibition on direct discrimination and also indirect discrimination, and as it then explains in the opening of 41, unless objectively justified and proportionate to the aim pursued. This is not couched in terms of derogation, and one can see the relevant anti-discrimination provision in this case, which is set out at paragraph 3 of the judgment at 826. The state parties to the present covenant undertake to guarantee that the rights enunciated in the present covenant will be exercised without discrimination of any kind as to national origin. That's the underlying vision. And then the provision that's of EU law that is in issue is at paragraph 7, which is Article 24.1, which we have looked at repeatedly already. So that is the explanation the court gives as to what equal treatment means in the context of Article 21, paragraphs 40
Very well,
and 41.
that's helpful.
And then we have the court's analysis of what the relevant type of discrimination is at 40 to 46.
Yes.
It's fair, it is, as Lord Hope said, fairly terse. But in my submission, it's clear that they approach the matter as a composite test.
Yes.
The next,
But I think what you've got to do, I mean, time is short. We've seen how these cases work. And Mr. Burton doesn't disagree with your analysis of how they work. But he focuses on the fact, however, that the kind of prohibition that we're dealing with in this case, or the kind of discriminatory criterion, is different from the ones that were being considered there. And that's really the issue between you which you need to focus on.
And that in my submission is quite, at least in large part, because the appellant and Mr. Burton misidentified the target.
Yes, that may well be so. I'm just thinking, because time is short, showing us what the general reasoning is probably an unnecessary exercise, as we understand that. It's meeting Mr. Burton's points of distinction that will be most helpful to us.
The first point I make is the one that I've already foreshadowed. If one goes to Appellant needs,
Yes.
at tab 54 of volume 3, page 1823. There one has the explanation or summary of the relevant domestic legislation, the State Pension Credit Act 2002, which in common with a number of pieces of the welfare benefits legislation have a requirement that someone is in Great Britain. And then that is then spelt out. That on its face, one might think it made sense on its own, but actually that is then spelt out in regulations, which are then, the relevant one is set out at paragraph 7. And then that is where one has the right to reside element appears at regulation 2.2, which is by letter E on page 1824. And my first submission is that once one correctly understands the way in which section 185 works and fits into its statutory regime, there is no material difference between that and the situation that we have in Pat Malnice. There is a general, at most indirectly discriminatory provision that is imposed on everyone, and then that is unpicked and expanded upon by a complex set of regulations, including a requirement that one has a right to reside, which any British citizen will meet, and some, but not all, many EU citizens will also meet.
I mean, in a sense, the core of your answer to Mr. Burton is in the submission that you made earlier, helpfully, when you were spelling out under 4 points the consequences of how the domestic scheme worked.
Yes, and the key point is that the point I want to take from Pat Malnice is the court very clearly, relying on Bressol, set its face against the idea that one can pick through a set of composite complex provisions and find one that's directly discriminatory, and on that basis decide that the whole thing is. One has to look at the package as a whole. And as I have said earlier, it is not the case. It is the case that UK citizens can fail the package under section 185(1). EU citizens, many of them.
Yeah, well, that's the point you made. Yeah.
And in my submission, key point from Pat Malnice is that is the correct approach to analysing this kind of case. In my submission, the subsumption point that my learned friend made, to the extent that the court, the Supreme Court in Pat Malnice can be said to have adopted an extra requirement, in my submission, or to have seen that as an essential element. My primary submission is that's not the correct reading of their case, but to the extent they do, there is, under the Housing Act, under section 185 and its package of provisions and regulations, there is a similar exercise of subsumption Because again, it's section 1851 that's the actual thing that is applied to and prevents, in this case, the appellant from receiving housing assistance.
Yes. Now, I see the time.
Yes.
How much longer are you? I mean, speaking for myself, you may say this can't be right. I think I understand your answer. I think we need to go to Pat Monese and Fertre any further. I think I see what your distinction from them is.
Yes.
My lord, my lady may have other points they want to hear you on. The other one I think we need to hear you from is Mr. Cox's first point about derogation. What else were you wanting to cover?
I wanted to briefly take your lordships and your lady to commission in the UK, which in my submission is an important case. Which
Okay, well, if it's important, you must take us to it. But I'm just worried about how you're going to do it in the remaining time.
Zeros.
Let's just see. After we've said we will take some time this afternoon, a limited time, to look at 1 or 2 more points about ground 1, which come out of Miss Smythe's note. After you have finished, Mr. Cox, what was your deal?
10 minutes.
10 minutes
Reply.
each for reply, and didn't Mr. Burton get anything? I see, right. Well, you'll have to liaise with him. How much longer do you think you need, Mr. Burton?
Cornwall.
Cornwall, so sorry. I do know the difference now.
There's so many council.
It is. It's very difficult for an old man like me.
I'll try and keep it to 10 minutes.
I'm inclined to finish this.
Yes.
You happy? I'm inclined to finish this before we rise. Okay, we are going to finish on ground 2, but you will find yourself under increasing pressure and be very succinct. So will Mr. Cox in reply, if he feels he needs to reply at all. And then we will, when we discovered when we finished, we'll tell you when we'll sit again after lunch. Okay, off you go.
Right. So that's the point I take from Pat Monese. If we then move on to Commission and the UK, which is a case that was decided by the Court of Justice after Pat Monese.
Yeah.
It was on an infraction proceedings by the Commission in relation to the right to reside test.
Yeah.
The Supreme Court in Pat Monese was aware that infraction proceedings were underway, but went ahead and made their
Okay,
decision.
don't worry about details. Yes, where do we find Commission in UK?
We find it at tab 15, volume 1 of the Authorities Bundle. Starts at page 478.
Yeah, we have it.
And the Commission ran the arguments, this was in relation, by the time this reached the court, it had narrowed down to right to reside test in relation to child tax credit and child benefit. The Commission argued that discrimination was directly discriminatory.
Yeah.
As you'll see from page 513, the Commission specifically relied on Advocate General Sharpstone's opinion.
Yeah.
So that's paragraph 35. The UK argued that the correct approach was that in Bressol.
By the court in Bressol. Yeah.
Taken by the court in Bressol.
Yeah.
And we see the court's analysis of what they put as the complaint in the alternative at paragraphs 74 through to 78.
Yeah.
Where they noted that paragraph 75 is nothing to prevent, in principle, the grant of social benefits to union citizens who are not economically active being made subject to substantive condition that those citizens meet the necessary requirements possessing a right to reside lawfully in the host member state. And of course, that was at a time when there was no right, it was under EU law, so there was no right, not being economically active and not being self-sufficient was essentially coextensive with not having a right to reside, they then refer to Bressel
Hang on, but we have to know what it says at 76.
at 77.
Well, I'm on at 76.
76, yes. So 76. So if your ships and your lady could read 76 to 78.
Yes.
So that's quite clear that Bressel, A, is not some random turning by the court, but is a position the court has adopted and affirmed. And it's also one the court has specifically applied in the context of UK right to reside test, albeit in a different context.
Right.
And in my submission that the statement at 78, that legislation gives rise to unequal treatment between UK nationals and nationals of other member states, as such a residence could be more easily satisfied by United Kingdom nationals. That is precisely the situation that we have here with the provisions under section 185.
Okay. Well, I think is that all you need from
That's all I need from.
EC and Commission?
Sorry, just one point. I want to go back to the one statement from the Advocate General,
Paragraph.
which is at page 497.
Yeah. Which paragraph?
Paragraph 75, where the Advocate General makes.
Can we just read it first?
Yes. Why court simply read it?
Yeah.
So the point is that that discrimination is inherent in the EU acquis. I then move on to Fertre in the High Court, which is at tab 2.
And
sorry,
why do we
tab
need
50,
to see? Why do we need to see this?
because it's the reasoning that's adopted and approved by Mr. Lord Justice Dingmans in
Okay.
the Court of Appeal.
Right.
I accept it's overture, but I say the analysis.
Yeah. Okay. Fine.
Ms.
So what
Justice
you're
Smith is
adopting is your
correct.
submissions. Where do we find it?
That is at volume 2, tab 50, page 1689. So, first point is paragraph 28, where Mr. Justice Swift says that he says it's difficult to see how the right to reside requirement under consideration in that case could even, if considered in isolation, comprise direct discrimination. 28 by letter, just above letter H. Paragraph 20, page 1689. Page 1689, paragraph 28. Have you got it, my lady?
Did you say?
Read the beginning of it again, which bit?
It's paragraph beginning, reading in his judgment, reading this judgment in Pat Moniz.
Carrot's egg. Yeah.
He then goes, it's difficult to see, so I'll let the court read the next.
How much do you want us to read?
Just down to the second from bottom line of that page.
I think what you're going to have to do, Mr. Cornwell, is say that you adopt the reasoning of Mr. Justice Swift
I will
and you adopt the reasoning of Lord Justice Dingerman's, which is to the same effect.
Yes, I dropped 28 and 29, and I dropped Lord Justice Dingerman's reasoning. So turning to my wrapping up. So
Well,
we say this is
yes,
squarely
would you, that will include the derogation point.
I will deal with the derogation.
Good.
Point.
Okay.
My lord, in my submission, the derogation point is fundamentally confused.
Yes.
That is because Article 24.1 of the CRD and Article 23.1 provide for a right of equal treatment. as the Court of Justice explained paragraphs 40 to 41 of Bressel, that right can be breached in two ways. One, by directly discriminating against someone, or two, by indirectly discriminating without justification.
Yes.
So that is inherent in the concept of equal treatment.
But the risk, but just to make sure, is your point that showing that something isn't discriminatory isn't a derogation?
No.
Derogation only operates where something otherwise would be discriminatory.
Exactly.
And your argument is, borne out by the passage you've shown us, that the things we're talking about here are reasons why it isn't discriminatory in the first place.
Yes.
Now, is that overstating it? Have I got that right?
That gets it spot on. The point about derogations in Article 23.2 is that, again, in relation to the field of social assistance, in respect of job seekers and those in the first 3 months, they are simply excluded from protection from that. That is a true derogation. They are exercising. They're residing in accordance with the directive and then the withdrawal agreement, respectively. But they are squarely residing, but they are still excluded from protection.
But I wonder if is that right if the premise which we're arguing is that they do fall within the right of equal treatment in the first place, because contrary to Brown 1, they are enjoying residence rights under the 13 of the Withdrawal Agreement.
Well, that is the ambitious proposition that Mr. Cox was advancing.
Yes.
That his argument
Just why is it wrong?
Then those derogations in the UK simply fall away. And I think my learned friend Ms. Smythe addressed you on why that's not a plausible outcome. Given the time, I will leave your lordships and your lady to reread what we say in our written submissions in the skeleton argument in relation to the swimming pool example that was raised by.
Oh well, that hasn't even been raised.
And again, Mr. Burton's written submissions, which were not pursued orally. You have our.
Well, to be fair, I mean, I'm sure he was. Things are not abandoned by being in the written submissions, but you're right to focus on the points that he made orally, which I think you've done.
Neither.
And the same applies for both sides. Yep.
So we say that this is squarely a case. If one focuses on correct construction of the relevant provisions and substance, this is a case which is covered by the rules in Appellant and in Bressel.
Thank you. Yes, thank you very much, Mr. Cornwell. Sorry you were under such time pressure, but I'm afraid so is everyone else.
My Lord, I
Including
like to
you,
make
Mr.
one
Cox.
short point, but if I might, when concluding that, sit down and see the rest of my time to Mr. Burton to reply to the points that he's made.
He's looking surprised.
This is a gift he was looking forward to. Anyway, let's have your short point.
There was no answer in those submissions to the unlawful derogation point.
Okay. Well, I think there was. You just think it was a good one.
Well, the answer is that there is no discrimination, my Lord, and that misunderstands the point of the system of rules. The system of rules is expressly intended to exclude those people who do not have the broader Article 13 right to reside, which presumptively this court has accepted exists.
Okay. Anyway, you're saying no answer to the unlawful derogation point.
I'm taking the point, my Lord, that when the point that you put to Mr. Cornwall, that there must be discrimination in order for the question to arise.
Yes.
There's a prior question, which is this treating people differently on the basis of their status under the withdrawal agreement? That is prohibited by Article 23.1 unless it falls in the derogation in Article 23.2. And this is treating people differently on the basis of their status under the withdrawal agreement, which is always discrimination on nationality grounds. because the only people who fall under the withdrawal agreement in the UK are EU citizens, and the only people who fall under it in Spain, and the only people who fall under it in Spain are UK citizens. It's always discrimination on nationality grounds.
Okay.
That's my reply.
Yes, Mr. Burton.
My lady, my lords, I won't take up whatever time was just allocated. I'll just make 3 quick points. The first, the Secretary of State's reliance on section 1851 as being the subsuming provision makes no sense because it has no substantive content.
Well, it does. It provides for 2 conditions: person from abroad and ineligible as subsequently explained.
Second answer to that, which I was going to treat as my second point, is if you look at both of those as a combined set of rules and sort of try and treat them holistically in that way, the problem with that analysis is there is no single substantive test. They go separately like this and they never come back together. So it makes no sense to try and subsume one or the other or analyse in the same way that was analysed in Bressel and Pat. There are 2 paths with no single test. Even habitual residence is not a single test that applies to EU nationals. The third point is that my learned friend provides no answer to the majority's approach in Fertre other than to rely on Dingelman's minority opinion. And the problem with that is the same problem as I mentioned earlier that we have in the first instance, which is contrary to the opinion of Lord Hope, a right to reside test is directly discriminatory. So Lord Justice Dingelman's adopts Mr. Justice Swift's analysis, which is all predicated on that same error.
That's the point you made.
Yeah, and that error is right the way through the analysis and therefore undermines all of it. Can I just, if it's not unfair of me, just coming back on the point about the UK and the Commission, AIR does raise 2 other decisions of the European Court in its skeleton, which I didn't have time to mention before. They're at paragraphs 36, D and E, and it's Martinez Sala, which predates Bressel.
And S is the other one, isn't it?
Yes, exactly. And what they show is they support, in my view, the majority's opinion, albeit not referred to in Fertre, because they are cases where you did have a carve-out for a very specific rule.
Well, it possibly is unfair because you've all been under time constraints. I'm aware of those cases, just they're referred to in your Stillington argument. Mr. Cornwell and Ms. Smythe, in their Stillington argument, address those points. I think we'll have to read those cases for ourselves.
That's what I was going to invite you to do. I wanted to be fair about it, but they are dealt with in written submissions.
No, but I don't think we should have oral submissions about them.
No.
We will sit again at, I think I'll say 2:20, and we will hear submissions only on round 1, and we will not expect to take up a whole hour, particularly since we've overrun this morning. We will take as long as we need to deal with the points that have to be dealt with. And of course, Mr. Cox, you'll be wanting to spend time you probably haven't had up till now looking at the note provided by Ms. Smythe overnight. Just give me a moment while I get it for myself. Here we are. 2:20.
All right.